The Honorable Judges of the Court of Appeals of the State of Alaska. The Court of Appeals is now in session.
Good morning. We are here this morning for the argument in Mollica v. State, file number A13046. Are the parties ready to proceed?
Yes, Your Honor. Yes.
Okay. Ms. Jura, you may begin.
Thank you. My name is Emily Jura, and I represent the appellant, Robert Mollica, in this matter. Therapeutic courts function very similar to probation. Essentially, they are a form of probation. They offer an alternative to incarceration and an opportunity to return to their lives in exchange for pleading guilty and agreeing to follow a set of rules. And the primary purpose of therapeutic courts, just like probation, is to rehabilitate defendants.
I'm sorry, Ms. Jura, I'm having problems hearing you. I don't know if it's just my connection or not.
No, I'm having problems hearing you too. A lot of static.
Let me try to speak up. Does this help?
That's better.
That's better.
Okay. I'll just lean in and get closer. Would the court like me to start again?
Yes.
Okay. Sorry. Therapeutic courts function very similarly to probation. Essentially, they are a kind of probation. Defendants. Sorry, is that better?
No, there's still a very strange noise. Does everyone else hear it?
Yes.
Yeah. Okay, now it's gone. So go ahead.
Okay.
It's every time you talk. Okay, we'll just
work with it.
Okay. Therapeutic courts offer defendants an alternative to incarceration and an opportunity to return to their lives in exchange for pleading guilty and agreeing to follow a set of rules. And the primary purpose of therapeutic court, just like probation, is to rehabilitate defendants. But when this benevolent purpose changes and the state terminate a defendant from therapeutic court, certain minimum protections are due. These are the same protections a defendant would receive in a traditional probation revocation proceeding. That is the dispute here. The state agrees that Mr. Mollica had a right to the same procedures of termination as a probationer has. What is whether Mr. Mollica was afforded those protections. Before I get into arguing why and how he was not, I wanted to first generally address how due process maps on to the therapeutic court proceedings and what that looks like. Is everybody still able to hear me?
not very well.
I can hear you. You're just cutting in and out a little bit and it's staticky, but I can hear you.
I could move to a different location. It may be that there's something in the office that I'm in. It would take about a minute. I don't know if it's...
Let's do that.
Okay. I'll sign off and send it.
Okay.
Okay.
Jura, can you hear me? This is Ryan in the courtroom.
Is it better? Can the court hear me now?
Much better.
Okay, great. So picking up where I left off, I just wanted to talk about how therapeutic court, how due process will look in therapeutic court. When the state decides that it wants to pursue termination, it needs to give the defendant written notice at a preliminary hearing. That written notice has to explain that termination is being pursued and why. And the why has two components. First, it's notice of the alleged conduct and the evidentiary basis for that conduct. And second, it's notice as to the theory of termination under the contract. At the final hearing, the state has the burden of presenting evidence to prove the allegations. That means that they need to present sworn testimony from a witness or witnesses with personal knowledge. And the defendant needs an opportunity to challenge the evidence and present its own. These hearings must be presided over by a neutral and independent decision maker. That means that the court cannot just defer to the treatment team's decision or opinions. It also means that the court cannot rely on information from treatment team meetings that have not been established in open court. And it also means that the court must explain its decision, including how it resolved the evidence, the defenses that were raised, and the contractual requirements for termination.
Mr. What about
default procedures that must be provided?
Mr. Can I ask a question?
Unless the defendant knowingly waives them. And I'm sorry, Judge Alla, do you have a question?
I had a question first.
I'm not able to hear you.
Oh no. Right now? No, you can't hear me? Can you guys hear me?
Yeah, I can't.
Yes, I can hear you.
Yes.
Can you hear any of us, Mr.
Can you hear any of us?
I just call into court.
Oh no. Oh dear. Can you hear anyone? Mr. Can you hear Ryan? Can you see if Mr. Can hear you?
Okay, I'm going to test my audio.
I am attempting to have her test her audio.
Okay, could somebody try something now?
Sure. Can you hear now?
Yes.
Okay, great. So my question was, some jurisdictions, when they talk about a neutral fact finder, require that to be a judge who is not the drug court judge or the treatment provider, the judge. But that does not seem to be what you're requesting here. Is that correct? That's
not my position here, no. Partly because that wasn't requested below, and I don't think that would constitute an obvious error.
So that gets to the other question, which is what was requested below? I mean, it seems there's certainly an issue of waiver here in terms of there was a hearing, there was an opportunity to present, there was no objection to anything. It seems as though that there was certainly constructive notice that he knew that he was facing termination, and constructive notice as to the reasons why, and he never complained or requested anything additional to what he received.
There's two very different components to your question. So I'll start with about the neutral fact finder and whether or not a judge needs to be brought in for the final termination proceeding. I think one state court said that essentially if a defendant requests a recusal, that should be liberally granted. And that would be my position as well. That if a defendant requests it, I think that the court should recuse itself. But if there's no request for a recusal and the court itself feels that it can be fair and impartial, then I think it can sit. However, if a therapeutic court judge feels like it needs to consider information that has never been established in court, it should seriously consider recusal. The second component of your question, yes, we need to meet the plain error standard because there was no objection below. In this context, I think that means that we're talking about whether or not the errors are obvious. I tried to limit my due process claims to what appeared to be the core component, what are the core components of due process, so that we are staying within what would be obvious error. As to your subpart question about notice, so what's required by due process, and this is required because it reduces the risk of erroneous deprivation, is formal written notice. And there are several sort of sub-protections of formal written notice. Everybody's on the same page about what is at issue, what needs to be proven, what the boundaries of the proceedings are. It's clear from the record that there's adequate time to prepare a defense and what the defense needs to be in response to. And none of those things are promoted by constructive notice or informal notice, the idea that the defendant must have learned somewhere along the way. In this case, I think demonstrates that. Mr. Mollica got constructive notice of some things, but the parameters of that are really unclear. What it does appear that Mr. Mollica got constructive notice of is that his conduct from September 14th and 15th was at issue. And that's what he was heard in regards to. And he defended himself by saying, yes, I did relapse, but after relapsing, I did what I could to mitigate the damage of that within therapeutic court. I avoided other therapeutic court participants, and I turned myself in shortly thereafter. He did not receive even constructive notice of other allegations. For instance, it doesn't appear that he got constructive notice that the therapeutic court judge had decided or was contemplating that he drove that day, or that he had this manipulative conversation with his girlfriend, or that he had brought an intoxicated female to therapeutic court. So we don't even have constructive notice there. But
Ms. Sarah, can I ask you a question? So the state's basically arguing, I think, that the conduct that happened on September 14th and 15th was essentially the basis for the discharge consideration, and that ultimately these other kind of this other conduct that the judge talked about at the final discharge hearing was other conduct that judges are always entitled to consider when they're considering whether to revoke somebody's probation. Why are we not in that world where, the notice of the allegations was essentially the criminal conduct or alleged criminal conduct on September 14th and 15th that he got formal notice of through the PTRP, the third PTRP. And then the judge was ultimately deciding whether to discharge him from the program, which was essentially a revocation decision because the judge was going to send him back to jail to serve time if she did discharge him from the program.
Two responses to that. First, it's really not clear from the record and the findings that the trial court made that its decision was Mr. Mollica is eligible or potentially could be terminated based on the September 14th, 15th conduct, and then I'm making this holistic decision based on the entirety of his conduct. It really appears in the way that it unfolded that the therapeutic court judge was saying, because you did not just the September 14th and 15th conduct, but this other factual conduct that you've never received notice of, you're eligible for termination and I'm going to terminate you. The other issue is therapeutic court is really different from probation in one way, which is that the judge has extrajudicial information. And so the therapeutic court judge has to be particularly careful to make sure that its evaluation of the totality of the conduct that the defendant has had the opportunity to respond to it and has notice of it. That's just required as a matter of due process. In probation, we don't have that problem because everything that the judge knows is part of the record. So everything that the judge is commenting on and is considering, the defendant has had notice of the opportunity at some point to discuss or respond to. And it's different in the therapeutic court context where Mr. Mollica is for the first time hearing factual allegations and decisions that he's never had a chance to respond to, as well as sort of attitudes and opinions about him that he's never had the chance to respond to.
But why should we, we're in a plain error world, right? And so shouldn't we presume under these unusual circumstances, which are different than the typical adversarial proceeding, we're in a therapeutic court world. He agreed in the Rule 11, my read of the Rule 11 agreement is that it says the decision regarding discharge will be discussed by the team and these discussions will not necessarily be placed on the record. So he agreed to that when he entered into the Rule 11 agreement. Shouldn't we presume that he's getting notice through his attorney who's participating in those off-record discussions, at least for purposes of plain error? And for example, there's an indication in the October 5th hearing, which is where the judge ultimately discharges him from the program, that he seems to know that he's being discharged because he off the bat immediately sort of asks for the court's recommendation for RSAT, which of course is an in-custody program. So there's clearly indications that these discussions are going on off record. And if we're in a plain error world, shouldn't we assume that he's getting notice?
The crux of my argument is that instead of an adversarial hearing that he was entitled to, where as a component of that, he gets formal notice, he gets the opportunity to contest the allegations against him. Instead of that procedure, what he got was a sort of summary hearing where he was discharged. That is the crux of my argument. And that, I think, meets the obviousness standard. Everybody agrees that Mr. Mollica was entitled to due process, and that's really not what he got below. The individual components of, he got some constructive notice, he got an opportunity to respond to some allegations. I think that those things don't, in their totality, reduce the risk of an erroneous deprivation here. And obviousness in this context, the Supreme Court has talked about obviousness being the least important component of the plain error test, and has talked about when we think about obviousness, we need to think about the degree and the magnitude of the error at issue. And here I'm talking about a wholesale sort of absence of due process. The magnitude of that error, the scope of that error is significant in determining obviousness. The fact that on appeal, we all agree that Mr. Mollica was entitled to a formal adversarial process that he didn't receive, I think all establishes obviousness in this context. I understand that he received some constructive notice, that's reflected in the record, but it's not the kind of notice that he was entitled to, and it's not the kind of notice that in combination with the other procedures he was deprived of reduces the risk of erroneous deprivation in here to an acceptable level, such that we can say that the court wouldn't have made a different decision if Mr. Mollica had been afforded these protections.
So, Ms. Jura, back to the waiver issue. I was curious about the hearing that wasn't transcribed, but our law clerk listened to it. I think it's either September 18th or September 20th, the actual PTRP proceeding where Mr. Mollica admits to the allegations involving the third PTRP. So why is that not, he's received notice of the PTRP allegations. He is certainly was entitled to a formal hearing at that point, and he waived that and admitted to the allegations.
Right. So I agree he received constructive notice of the September 14th and 15th conduct, specifically the judge telling him that he blew off therapeutic court and that he committed additional criminal conduct. He responded to those allegations in the therapeutic context where 7.5 years of his liberty was at stake, and he denied committing additional conduct. In the formal the criminal trespass PTR hearing, he did admit to the conduct. But as I wrote in my brief in a footnote, he faced 10 days in jail as a sanction for that conduct. That's different in kind than the 7.5 years that he faced in the therapeutic court context. And in that context, he disputed that conduct and that it amounted to criminal trespass. And on its face, the conduct as alleged in the third PTR does not constitute criminal trespass. So I don't think that this court should find any form of estoppel based on him admitting for a 10-day sanction in order to sort of resolve the proceeding, that in this other context, when he faced a significant loss of liberty and where he actively disputed that should preclude it.
What were the actual violations he admitted to in the PTRP proceeding?
It was that he,
was it trespass?
I believe it was trespass.
Okay.
I'll just double check.
Where did he actively dispute the trespass in the other hearing? I mean, I understand that he had an explanation, which was it wasn't really meant to be a trespass. I was trying to turn myself in, but I don't necessarily see where he says this wasn't trespass.
Well, he doesn't say this wasn't trespass, but what he said would constitute a defense to trespass, which is I went there to turn myself in, not that I went there in order to try to break in. I went there in order to commit a crime. Those are the things that would constitute.
Trespass doesn't require you have to commit a crime. It's just you're someplace where you're not supposed to be.
There's two forms of criminal trespass. One is that you're on a place, a public place with the intent to commit a crime, and the other is that you're there non-consensually. So he doesn't fit either of those prongs.
Was it clear which one he was being charged with?
No.
In order for him to be discharged, there's a requirement that there's first progressive sanctions and that there have been treatment adjustments made. So when the court is making this decision to discharge, you're indicating there needs to be notice of the basis for the discharge, but doesn't that necessarily include things that have happened previously that may not have been on the record? And how would that, to what extent would notice be required of those previous informal adjudications that happened?
Yeah, I think it should be included in the written notice.
So you're not saying, you're not limiting your argument to saying that he needed notice just of these narrow allegations that precipitated this, but actually quite a bit more.
Yeah, he needs a roadmap for how it is that he's the court or the state is seeking to terminate him. And he needs that under due process so that he can prepare his defense.
Isn't it the case that, I mean, it seems that the earlier, he wasn't in therapeutic court for very long, and early on he commits this assault. And then soon after getting out from the assault, he then takes off and doesn't return to his housing and doesn't attend his programming. It seems as though that he was certainly on notice, or it sounds like from looking at the record that the judge had previously put him on notice that, you know, the assault alone was reasons to discharge him, and that there was some sort of meeting or discussion where they decided, notwithstanding that, they were going to give him another chance. So isn't he already on notice that I'm on thin ice here?
Well, there's nothing in the record establishing or suggesting that the treatment team or the judge at any point told him, if you make even the most minute of mistake here on, you'll be gone. So there's not that kind of notice. And what I think Mr. Mollica could have argued below, if this had all been laid out for him, is that his behavior was de-escalating. So the first issue where he assaulted his girlfriend, that appeared to be the result of a relapse. The second relapse in therapeutic court, and this is only the second, and of course the contract contemplates that people will be relapsing 4 or 5 times before they're discharged. So the second time he relapsed, he mitigates the damage from that. He avoids people who would be made vulnerable due to his relapse, and then he seeks to turn himself in shortly thereafter. So I think a court certainly could have concluded that, yeah, Mr. Mollica, you made a mistake by relapsing again, but you didn't do the same things that you did before. So I see some encouragement in that. And the fact that you're seeking to mitigate that conduct in therapeutic court, the fact that you're being honest here today with me, are all encouraging signs that we can continue to move forward with you in this program. So no, I don't agree that because he made a mistake previously that was on the major end, that he was therefore sort of right at the edge and he didn't need these protections, and his discharge would have been inevitable.
Mr. Your argument is limited to just, you're really talking here about rights that attach at the time of discharge from the program, not along the way.
Correct.
And I think the La Placa court at least declined to consider sort of along the way problems and said, look, we're just looking at what happens at the ultimate discharge stage. To the extent that this error must have been obvious to the court, how do you, why do you draw the line there and say that this may not apply at those other stages? Or would it be equally obvious along the way that for every little incarceration, there has to be some sort of due process afforded for every sanction?
No, I don't think that would constitute plain error. I don't think that that is error. I think as long as the therapeutic court is using sanctions as a method for ultimately rehabilitating the defendant, that is all fine. The liberty interest at that point is, of course, much smaller. We're talking about a couple days in jail, that kind of thing. And we're also, the benevolent purpose is still in place. So, but that all changes when termination is what is sought. Then we have the very significant liberty interest of the defendant, and there's no longer that benevolent purpose. There's a shift. And so there needs to be a shift in the formal procedure to match that.
So you have to have this benevolent purpose, and also a lengthy incarceration to trigger an obvious error here, or?
Correct. Because the defendant's conditional liberty is not, for intermediate sanctions, his conditional liberty is not really at stake. The jail is being used as a tool in order to ensure that the defendant can continue with his conditional liberty, if that makes sense.
So in one instance, there would be no error, and in the other instance, the error is obvious.
Correct.
All right.
I think we've addressed my argument about how Mr. Mollica was deprived of due process. If there are no other questions, I'd like to move on to the appellate waiver issue. So
when I was preparing for oral argument, it occurred to me that I may have misunderstood the state's argument about the scope of the waiver. I understood it as the state is arguing that Mr. Mollica could move forward with his due process claim, but not with any claim about the discretionary decision made by the judge. If I was wrong in interpreting that argument, I intend to address that in my rebuttal. But right now, I just wanted to touch on why Mr. Mollica's waiver was not knowingly done, and also why enforcement of that waiver would be against public policy. So many courts recognize that it's difficult, if not impossible, to knowingly waive a prospective right, meaning a right that has not yet been implicated and the circumstances under which it would be implicated have not yet come to fruition. To the extent that this court is willing to enforce waiver of a prospective right, it should require an on-the-record inquiry at the time that the right is waived. The federal courts require this as part of their rules, and doing this would ensure that at least the abstract nature of the right is explained to the defendant, and that the defendant acknowledges an understanding of it. Here, the record is obviously inadequate to establish a knowing waiver. There is no on-the-record inquiry at all about waiver of this prospective right. And the information that Mr. Mollica is given, much like in United States versus Teeter, is ambiguous and muddled. So he's told at one point that he waives any appellate right in relation to a future termination decision, and he's told at a separate point in the same contract that he has no right to that kind of appeal. And so under these circumstances, that's not enough to establish a waiver of this very important right, particularly in its prospective form.
So I wanted to ask you a question about that argument, because it seems a little bit like you're playing semantics. If essentially he's on notice that by opting into this program, it includes waiving my appellate rights, then it is not untrue to say you have no appellate rights in this program. So I guess I don't necessarily see that you don't have appellate rights necessarily means that he doesn't understand that those are his rights to waive.
The way that this should look, and in United States versus Teeter, it lays out what it says in the document. It says, you, Mr. Defendant, have the right to appeal X decision. You are agreeing to waive that right as part of entering into this agreement. That is what is needed to establish a knowing waiver. He's not told that at any point.
But there's no therapeutic court. I mean, under the terms of the contract, there's no therapeutic court where you can preserve that right. It's part and parcel of entering into the therapeutic court, right?
Well, my understanding of the state's argument is that defendants are, bargaining to give up this right. That's, I think, a premise of the idea of waiver, is that you are bargaining and giving it up. So that means that you have the right, and that means that needs to be explained to defendants if they are waiving that right.
Well, it says at the end of the Rule 11, I understand and agree to waive any appeal of decisions made by the court as to sanctions and or discharge from the program.
Yes, so that is ambiguous.
So all you're saying is that there needed to be a prefatory statement that said you have this right?
Yes, it needs to say that, and there needs to not be language elsewhere in the document telling the person that they don't have the right.
Don't those two things need to be read together? Like, obviously, if he's waiving the right, he had a right to waive.
Well, it says you waive any right to. It doesn't affirmatively say you have a right and then you waive it. So he's never told that.
But what would he be waiving if he didn't have the right to begin with?
It is common in the English language to say, to the extent that something exists, you are doing X with it. It's not acknowledging that X exists. It's just saying, if it does, you are giving it up. That is how I take that language. Is like, it doesn't affirmatively declare you have the right and you are agreeing to waive it. It's saying, to the extent that this exists, you're agreeing that it goes away. And perhaps that is formalistic, but this is a knowing waiver of an important right. It's not too much to ask that it be explained to the defendant that he has the right. It's not too much to ask that the court go over with the defendant. Do you understand that you have this right? Do you understand what that right is? Do you understand that that right is going away by entering into this agreement? Those are things that...
Was he explained that as part of the change of plea? Was the change of plea on the criminal mischief charge separate? And was he explained his right to appeal in that context?
So it all occurred at the same proceeding.
It all occurred at the same proceeding.
Yeah, he waived his right to appeal the underlying criminal mischief, issues and motions related to that.
Okay.
So that was a very narrow scope of the appellate waiver that he gave up. And frankly, I think what that means by implication is that he retained any other appellate right that's not included in that. So I don't think you can infer from the limited waiver of one appellate right that he understood he was giving up other appellate rights, if that makes sense.
I have actually a related question. Is the criminal mischief case before us, or is it just the PTRP case?
It is just the PTR case.
And so you're not contesting due process with respect to discharge from the program in relation to the criminal mischief?
It wasn't appealed.
Okay. But he was discharged from, like, essentially in both cases at the same time.
He was, but it was contemplated at the termination proceeding that he could seek to be readmitted as to the PTR alone after serving the criminal mischief time. And we are where we are, that Mr. Mollica appealed only the PTR decision. So, there's nothing to preclude him from this court finding error as to the PTR, which is before it, and him seeking readmittance based on the PTR alone. So he would, you're just saying as a practical matter, he didn't file a notice of appeal as to the criminal mischief charge. Okay. I also wanted to discuss why enforcement of the appellate waiver would be against public policy. And I have 3 reasons. First, there is no justification for it. Second, it's a clause of adhesion. And third, it will make therapeutic courts worse, not better, and it will undermine our judicial system. As to the first issue, the state has said that this clause is necessary so that the court can consider information that it learns in off-the-record treatment meetings without ever making a record about this information. I think that the response to that is easy. Therapeutic courts should not be doing that. Therapeutic courts need to make decisions about termination based on what is established in open court, and what the defendant has notice of. If the court feels compelled to consider something that has not been established in open court, it should provide notice on the record and give the defendant an opportunity to respond. So the state's justification for this clause, I think, is not valid and subverts due process. Second, this clause is a clause of adhesion. Defendants are in a take it or leave it position. Certainly they can and do negotiate what their eventual sentence would be, but they have little leverage or incentive to negotiate the functioning of therapeutic courts.
Sure, isn't that true of all of the aspects of therapeutic court? I mean, again, it's this kind of part and parcel. You agree to go to therapeutic court, you agree that your lawyer becomes part of a team, that it's non-adversarial, that there are these off-the-record meetings that you can't participate in. Why wouldn't the same argument then be to strike down all of those requirements and just say none of this works, all of this violates?
Because the appellate waiver clause is a particularly noxious contract of adhesion, meaning that all it does is it insulates clearly erroneous and clearly mistaken decisions from appellate review. And that could have the effect of encouraging or perpetuating these same kind of mistakes to be made over and over, because courts are going to be used to deciding these things in a certain way, and because they're never going to be corrected on appeal. Enforcement of this clause would make therapeutic courts worse, because defendants who are in them will suffer legal wrongs, and they will never be able to get a remedy for that. And I think therapeutic courts are different from other aspects of our system, because there is no rule or statute regulating termination. And so all we have really is the development of law through jurisprudence. And enforcement of this appellate waiver, which, as you know, we all understand is a contract clause, and every contract would effectively preclude judicial review, insulating these decisions from ever being reviewed, insulating these courts from ever being corrected, allowing and tolerating all these variances and errors across the state. So for those reasons, I think it would be against public policy and fundamentally unfair to enforce this appellate waiver. If there are no further questions, I would save the remainder of my time for rebuttal.
Ms. Clarabod?
My name is Teresa Klebrad, and I represent the state of Alaska. Can you hear me well enough with me actually using my phone?
Mm-hmm.
Yes.
The real question in this case isn't whether Mr. Mollica received due process, but whether the process that he received was good enough, given that the special therapeutic court that he wanted to opt into, This is not a case where the state went out and tried to get him to opt into this special program. He sought out this program. And the program is one where the court says, these are the parameters and the rules of the program we have to provide for you. If you want to participate in it, you have to do so voluntarily. The defendant goes in with his eyes wide open as to the requirements, the parameters, and the limitations. And for that reason, I want to go into a few details about the therapeutic court. Some of this is apparent from the policies and procedures manual, some of it's apparent from the record, and some of it is some common sense, because a lot of information about the therapeutic is actually not on the record because the defendant did not dispute anything about due process in the trial court. The therapeutic court is a huge commitment of time and money to help defendants who have special problems, like addictions to alcohol and drugs, or there's a veterans court, there's other kinds of special therapeutic courts. And a team of people is dedicated to helping those people who also happen to commit crimes to overcome their problems or addictions, with the hope that they will not commit any more crimes and they will be rehabilitated from their personal problems and their criminal conduct. The structure of the court is a well-balanced whole rehabilitative program. And the arguments that the defendant is making here today pretty much turn the whole program upside down on its head and would be destructive of how the program works in its entirety.
Well, let me ask a quick question. What would be the problem with when you get to the point where the court's considering discharge to give notice of the grounds and perhaps all the considerations that are going into that decision in a more formal way, so that these hearings, that the final hearing, which arguably should be more adversarial, or arguably is more adversarial, is the parameters of that hearing are clearly established?
That would be a slippery slope, because there's so much that goes into the therapeutic court process that you would never be assured that you have enough of it on the record. Let's look, for example, at this whole process. It's a collaborative problem-solving process. For instance, there are the hearings that are on the record. When the defendant goes into the program, he has a hearing every week on the record. But before that happens, before each of those hearings, there are the private pre-meets. What happens with the pre-meets is the whole team attends those meetings. That means the probation officer, the judge, defense counsel, the prosecutor, the court administrator who oversees the program and monies that go to the defendant. For example, if defendant is getting financial help with his housing at the beginning of the program. There are also the therapists that may attend.
But this is all about sanctions of the regular runnings of the court. I think Judge Wallenberg's point is, at the point of time at which you reach terminations, Ms. Stur's point too, is that we are no longer in the benevolent world of the therapeutic court. We're now kicking somebody out of that benevolent world, and so that the procedure should be different. And I guess I want to just get clarity on the state's concessions, because I also was confused by them. Is the state conceding? So in your brief, you say that due process, that you don't dispute that he is entitled, that therapeutic court participants are entitled to due process. Right. And do you, by that, mean that you accept that you're conceding what the majority of jurisdictions seem to say, which is that the process is similar to the process outlined in Gagnon v. Scarpelli and Morrissey v. Brewster?
That would be it's not a yes or no answer. It's the defendant is entitled to due process, and if you look at the policy and procedure manual, it says that he's going to get due process, but it's a different form of due process.
So, okay, because there's very clear in the case law, there's very clear case law where a number of jurisdictions, including the model drug court, bench book or whatever, that they say that the procedures that should be followed should be on par with the procedures that are followed for parole revocation or for probation revocation. And that would include the written notice, the opportunity to be heard, the right to confront and cross-examine adverse witnesses, a neutral and detached hearing body, and a written statement by the fact finder as the evidence relied on and reasons for revoking parole. So those are from the United States Supreme Court in Morrissey. So those are basic, under Morrissey, those are basic due process. And I want to understand, are you saying, no, we don't agree that those are the basic due process that is required here? Or yes, we agree with those, but we think that they were substantially complied with in this case? Which is the state's position?
The Morrissey decision, the court called due process in this context a flexible concept. And I think it has to be a flexible concept here. The defendant is entitled to notice and an opportunity to be heard. He did receive it in this case, undoubtedly, but it doesn't have to be in writing. I would disagree with that. I would disagree that this process the adversarial process took a back seat to this whole procedure. It didn't have to be converted based on the agreement and the structure of the program the court set up. It didn't have to be converted back to an adversarial process for this for the discharge process to work.
Well, certainly, parole hearings remain adversarial, but they're pretty informal. And that's what a lot of jurisdictions seem to suggest is kind of the baseline of due process, is what you get in a parole hearing, you should at least get in the termination hearing.
And part of that, the defendant, I'm sorry.
No, I'm just trying to understand whether your argument is substantial compliance with those, or whether you're disputing in the first instance that those kinds of that this should be like a parole hearing.
This should not be like a typical probation revocation hearing. It's a hybrid process that is unique to the therapeutic courts. In this case, the defendant had lots of notice before he entered the court about the things that could lead to his discharge from the court. It was very specific, and he knew what his conduct was and that his conduct violated the agreement that he entered into. He would have known through his attorney who went to all the pre-meets. The way the pre-meets work is, and what would have happened in this case, is that when the defendant was incarcerated in Anchorage, his case would be flagged. It would show up on Apson that he was in this particular program. A probation officer on duty that weekend or at that time was contacted the defendant's probation officer. Much of what happens in these cases is done with emails to the members of the team. Emails went out, and very shortly thereafter, there was the hearing on the record where the defendant was not present. But it was clear that everybody knew what was going on there. I think if we were required to take this therapeutic approach that the court had been working with and the team had been working so hard on and turn it into an adversarial process, would change things entirely. It would take more time, and moreover, it would make ineffective the whole program in a couple of different ways.
So I guess the question, so it's now I think I understand the state's position better. You're not arguing for the majority position, or in fact arguing for minority position, not to have the due process protections that are equivalent to parole or probation revocations. And in fact, you're arguing for something that's more hybrid and doesn't look like a probation or parole revocation hearing. So that's correct, right? But
Yes,
certainly
that
the
is the way
majority
the-
position, the majority of jurisdictions have well-functioning therapeutic courts and do provide those protections. So why should it be that this would be the end of therapeutic courts, that this would be so detrimental when the majority position is that there should be those kinds of protections for termination hearings?
Well, there's a couple of reasons. One, let's look at the hearing process, what goes on the record in the therapeutic courts, the way they are set up in this state. In this state, all the defendants who participate in the therapeutic courts are required to attend the full length of the hearing, whether it's a few hours or all day, depending on how many participants are in the court at that time. They all have to listen to each other's cases. They're all part of a team that's supposed to support each other. When they hear another one of their fellow defendants making progress, they're supportive. They cheer him on. At the same time, when they hear that the defendant is doing poorly and is being sanctioned, it serves as kind of incentive for them not to go in that direction. Likewise, people who are considering going into the therapeutic court are required to go to a few of those hearings. Now, why do we want to keep what is in those hearings very general? It's because the other information in the case that goes on in the pre-meets is incredibly sensitive information. It can include information like somebody having certain diseases, HIV, or hepatitis C.
Certainly something about the way our therapeutic courts work would have to change probably, I think is your point, because there's such little information provided during those hearings because of this sensitive information that you're talking about, that it would require more to be put on the record at those hearings along the way. It sounds like under the way Alaska's courts work, that this business of coming into court and vaguely saying something positive or negative and either applauding or not would no longer be a sufficient hearing, that the state would really need to have something more clear put on the record at these intermediate hearings.
But isn't
That's
that
very true. I mean, the breadth of the private information is huge. I mean, you get into people's past traumas, unreported past sexual abuse, happenings with family members, things that you would not want to make public. There's another thing that happens.
Wait, one second. I want
to
address Judge Harbison's question, because Judge Harbison, my understanding of Ms. Jura's argument was that she's not saying that anything needs to change in any of the procedures except for the final procedure that involves discharge.
That is what she's saying, but she's also saying that it's certainly possible that you would have to consider what happened along the way at the final hearing, as I understand her argument. And what happens along the way currently, Ms. Klebrod is explaining to us, and certainly I've been a judge in these courts, is very little on the record along the way. Almost nothing.
Well, isn't there a middle ground? I mean, one thing that kind of surprised me is we got to the discharge hearing, which was several hearings in, and suddenly the judge was citing grounds 2 and 6 as the basis for discharge. One, that Mr. Mollica was undermining the progress of others in the therapeutic court program, and 2, that he wouldn't be able to make regular progress in the program because he required services that weren't otherwise provided. I mean, isn't that essentially the grounds on which he was discharged, and why wouldn't he be entitled to notice of those right up front when the treatment team is considering discharge, so that he has an opportunity to confront that? And then the evidence and then the treatment team could lay out the grounds that were specifically relevant, or the evidence that was specifically relevant to those grounds.
Are you back to me?
Yes.
We're done discussing amongst ourselves.
Oh, yes, sorry. Anyone jump in, yeah.
Well, I think it comes back to a few things that Judge Harbison started with, and again, and they're all interconnected. So providing this specific notice wouldn't work because of all the things that have gone before that are not on the record and that the judge and the team members are relying on in evaluating whether to sanction or discharge the defendant. In addition, there's something else that happens at the pre-meet, and that is that the members of the team wear different hats. Opposing counsel or defense counsel, while he's going to be an advocate for the defendant in court, he's not necessarily the same type of advocate in the pre-meets. He may say, listen, I know my client messed up. I don't think that he's taking this seriously enough. I think that the team should consider a more serious sanction to enable him to continue in the program. Otherwise, I'm afraid he will drop out. People will say things. They need to be open and candid and frank in those meetings. When you take that private information and you have to put it on the record in this public hearing where all these other defendants are present, it will not work. And I don't think you can eradicate the possibility of those problems by saying, let's give a more defined written notice of the reasons for this discharge. And I don't think it's really necessary because the defendant always has notice because his lawyer has been at that pre-meet. And moreover, he has agreed to this as a condition of participating in the program. What he does, another aspect that the court has to think about is how this program works. This program, while there's things like individual therapy, group therapy, there's lots of accountability provisions in it, but it's largely driven by very immediate consequences. You did well, and immediately the judge says, okay, you can leave the area and go fishing down in the Kenai, or a lot of that happens through emails. We don't have a record of what happened in this case because of that. The defendant, likewise, the immediacy of sanctions are a really important part of this program. And the court has said that in its policies and procedures manual. If you allow the defendant to appeal, you have stopped the program in its tracks.
Oh, so actually, I want to clarify your position on that. I too was not certain whether you were arguing that Mr. Mollica was precluded from appealing the absence of due process or his alleged absence of due process in this case, or are you conceding he can appeal that portion and just saying he had no right to appeal the actual termination?
I don't quite understand your question. What I would say.
Do you concede that he had the right that he can appeal the lack of due process issue?
Yes, he can appeal the lack of due process. But if he received due process, he cannot appeal the basis for the judge's decision. He can't appeal whether she abused her discretion in revoking or discharging him from the wellness court.
Okay, so Ms. Jura read your argument correctly in her reply brief.
I think she did in that regard, not so in others. So for the program to work, all of these things have to be adhered to. The defendant cannot have the right to appeal a sanction or a discharge from the program, because otherwise the defendant doesn't have to take seriously the sanctions or the discharge. He can operate through the program thinking, the court might do this, but I can always appeal. That pretty much negates how the court the therapeutic court works all together. Additionally, if the state and the court were required to work through a program that is now less effective because of the defendant's ability to challenge his appeal or to challenge his sanction or his discharge, the state would have to reevaluate whether it's going to continue to participate in this. And as this court recognized in the Geo Leonhardt decision, if these provisions in the agreement are not held valid, the state would not have an incentive to continue to participate. And that would be important because the state's consent to any defendant's participation is required in the program. One other thing I do have to point out when the court was asking questions about the revocation is you have to remember that the defendant, as to his underlying probation revocation issue, as a condition of being admitted to the program, he already admitted his guilt as to that charge. So once he was discharged from the program, the only issue for the judge to decide was not whether he had violated a probation condition, but what sentence he was going to impose.
I think our questions were more directed at the third probation revocation and the issue of his admission to the criminal trespass. I don't think anyone's confused about the fact that he's already admitted to the second probation revocation.
Okay.
So we're correct then in assuming that we do not need to reach the appellate issue then. Because if essentially the state is conceding that regardless of what that appellate waiver means, or whether it's contrary to public policy, or whether it was knowing and voluntary, nevertheless, he could proceed with this kind of appeal, which is exclusively addressing the due process protections or lack thereof.
That's true. I briefed the issue of the waiver of the right to appeal primarily because opposing counsel's brief, although she argued she was appealing the due process issue, she seemed to be arguing about the merits of the judge's decision as well. The merits of the judge's decision for discharging the defendant only mattered for the purpose of determining whether she tracked the reasons for the discharge to begin with what you could discern from the record in the Superior Court and to know the defendant received due process. But as to the merits of her decision, I don't think that is on the table.
My read of Ms. Durr's reply brief is she conceded she wasn't appealing that.
Right, and even though she conceded it, it seemed like her argument still tried to go to the merits, so I was confused about that. It appears to be maybe clarified here, this argument. Next, I would say Mollica did receive due process. It's not that he didn't receive any process, and I think he has acknowledged that. He's really arguing about whether the process he received was good enough in this hybrid situation. But the point is that in putting together this therapeutic court, the court system here has adopted a hybrid situation. And is that valid? Is that okay for the court to say, if you want special therapy, if you want all this help and special treatment that no one else can get in quite any other way, this is what we can provide you. Are you willing to do it under these terms? I don't think there's anything improper about saying this is what we have to offer. This is the due process that you will receive. It was told to the defendant in the form of the policy and procedure manual that's public, and it was told to the defendant in the agreement that he signed and the policy procedure manual that he said that he read 2 times. I don't think the agreement could be any more clear, given that paragraph about the waiver was right over his signature, and the number of places in the document that said these issues are going to be decided in off-the-record proceedings. So, you know, there was no hiding the ball here. I think when you read the hearings, the transcript of the hearings in context, you will see that Mr. Mollica always knew what issues were before the court. He went into the first hearing after September 14th and 15th, and he knew that his discharge was on the table. He knew the reasons for that. The fact that the court fleshed it out in many other ways based on what had gone in the pre-meets doesn't mean he was denied due process. He was afforded due process because he clearly understood that what was going on, and his lawyer would have been a participant in those meetings and would have protected his interest in those meetings, even though she could have been wearing more than one hat as his advocate at that time. The question is, do you want to allow the court to have a program that is balanced on all these different prongs, with the interest of the other defendants who participate, having the pre-meets operate with very confidential information, and then having the on-the-record hearings as they are?
Here, when the court made its disposition decision for the last PTRP, the court relied almost entirely on Mollica's failures, probation failures. And the bulk of those failures were things that happened along the way in therapeutic court. Is that right?
Yes, but there could have been other failures as well. There's a lot of sanctions. There could have been more minor sanctions that we know nothing about that the team handled through email or in the pre-meets that we will never know anything about, because information about those through the status reports at the pre-meets gets shredded after the meeting.
So to the extent that the court relied on those things that happened that Mollica knew nothing about, how is that a fair process?
I think the premise of your question is incorrect, that Mollica knew nothing about them. One, he committed whatever the thing was. Two, if the judge knew, that means that Mollica's lawyer also knew, because the judge would have gotten the information from the probation officer or other members of the team that presented it in the status reports or presented it verbally, and Mollica's lawyer would have been there to take in that information, and then she would have been able to provide that information to him. He chose to be in a program that was set up this way. I think it is unfair and disingenuous to criticize this aspect of the program when you know going in that this is the way the program is going to operate. The powers that be who have put together this program have figured out that this is the balance that works for this wellness court in Palmer. Last, I would say, as far as due process and Mollica's notice and opportunity to be heard, and I think the court noticed this in one of its decisions or one of its questions. Mollica, at one of the hearings, he acquiesced and seemed to understand and that he was going to go back to jail, because he asked the court whether the court would recommend for him to be place in a residential subsistence program. This was the opportunity he had to object and say, provide reasons for his disputing the court's findings and to dispute his discharge, but that's not the position that he took. So I think it's disingenuous for him to now argue that he did not have an opportunity to be heard. So as far as issues with respect to his discharge, he was given a huge break when he was allowed to stay in the program after the incident where he assaulted his girlfriend. There was another thing that could be gleaned from the record, that he was sanctioned for being late to a meeting. And we don't know what other sanctions were provided. So to the extent that the defendant is arguing that it was improper to discharge him at this point, I don't think that argument is well-founded.
Ms. Clarebond, you're past time. If you want to just wrap up and finish.
I think I've covered the state's position pretty well. The last thing I would say is the defendant's arguments really affect every aspect of this program. And I don't think that that is something that should happen in a case where the arguments were not developed in the trial court because the defendant did not raise these issues in the trial court. And thank you.
Chief Judge Allard, this is, excuse me, this is Ryan in the courtroom. Based off of my timekeeping, Ms. Jura technically has 0 minutes on rebuttal, but with all the difficulties at the beginning, it's very likely that that she probably lost a minute or two in the starting and stopping.
Let's go ahead and give her 2 more minutes.
Thank you.
Okay, Ms. Jura.
Thank you, Your Honor. What I heard entitled to a compromised form of due process that's lower than what probationers get, and they gave 3 reasons for that. First, because he volunteered for the program. Second, because it would turn the program on its head. And third, because he received lots of notice upfront about what could potentially lead to termination. I want to briefly address all 3 of those. First, it doesn't matter that he volunteered for it. It doesn't matter that he gets a potential benefit from it for due process purposes. People volunteer for welfare. People volunteer for probation. He gave up his right to trial and to maintain his innocence in order to enter into this program and get a fair shot. So he doesn't get a discount form of due process because he volunteered for it, just like how people who get welfare don't get a discount form of due process and people on probation don't get a discount form. Second, it doesn't turn the program on its head. This is not a huge adjustment. This is a shift to a formal, orderly process when the change in purpose also shifts. Things are discussed in pre-meets, that's true. But frankly, what is going to drive a termination decision is not the sensitive things that are revealed in therapy. It's not whether or not somebody has an STD. It's going to be about conduct, whether or not a defendant has relapsed too many times, whether or not they've missed too many UAs, whether or not they've missed groups. Those are not the, those are not the sensitive details that need to remain confidential and that should never be fleshed out. It's a simple bottom line. If the court at termination wants to rely on certain conduct, then it needs to explain what that conduct is so the defendant can respond to that. And to go to Judge Harbison's question, if the circumstances about that prior conduct are murky or unclear, then all the more reason that that needs to be fleshed out on the record and the defendant needs to get an opportunity to respond to it. I don't think that these things need to be, I don't think the pre-meet or the what happens leading up to a termination needs to be changed at all. To the extent that something comes, oh, sorry.
Yeah, Mr. Joseph, I just want to be clear. Your argument here is that not at the time of the discharge, there should be a hearing with regard to the basis for the termination in the sense of which parts of the contract were violated. Correct. And additionally, and here's really what I'm getting at. Additionally, the reason that the judge is now exercising her discretion to boot him. In other words, so if there are the things along the way, transgressions that were either clapped about or not in court, whatever those issues are, need to be fleshed out in the courtroom along the way or heard
as a matter of, in the first instance at the time of this hearing.
Correct. Yeah, I think most of the time, things that are conduct that's sanctionable is going to be brought out at the hearing at the time. But to the extent that doesn't happen, then all the more reason it needs to be brought out at termination. And I have an example. Let's say defendant was late to a group meeting because his child got sick. That's obviously a mitigating explanation. If it's not brought out on the record at the time, if he's not formally sanctioned at the time, but the court wants to consider at termination, then the defendant needs an opportunity to lay out that mitigating explanation. And if he didn't get it previously, he needs to get that at termination.
I have a quick question. Oh, sorry, you finished, Judge
So
Harbison.
at the time, just to go, I'm trying to think about what this would look like along the way. So let's suppose it's a lateness and there's going to be some kind of a sanction, or it's a missed UA and there's going to be 2 days in jail. Your position would be on the record at the hearing that is conducted along the way, that the judge would announce the person, say, had missed a UA and was going to have to serve 2 days in jail. And then does there have to be a formal admission to that in order for that to be later relied upon by the judge at the time of termination? Or does the thing just move along, or do you have to then rehash it at the time of termination?
I think if there was if it was discussed on the record and there was a formal sanction, then it's much easier to provide notice because you're just referencing back to such and such date, that sanction. And so at that point, the defendant's on notice. He can bring up any defenses that he didn't flesh out earlier, if that makes sense.
But I guess I'm trying, is that being adjudicated? Do you suggest there has to be an adjudication at that time? No.
No.
Okay. So
No.
just, we know that you missed a UA, and so you're going to have to do 2 days in jail. And that statement is then sufficient for the judge to rely upon that conduct later at the time of the termination.
I think it really simplifies the notification process. The court could just be like, on X and Y dates, you got these sanctions. It was about this conduct, that. And so the defendant, to the extent he has some defense that wasn't expressed before, will be able to lay that out.
So we're going to go ahead and take some extra time, so make sure everyone gets their questions answered. So Mr. I have a follow-up for that. My understanding is, from your position, is that it doesn't even necessarily need to be put on the record, a prior transgression to then be relied on at the termination hearing, as long as notice of it is given prior to the termination hearing and there's an opportunity to respond to it. So that there might be a transgression, for example, this incapacitated woman or intoxicated woman who he took that may never have been discussed formally, but could still be relied on at the termination hearing if notice had been given to him that this was one of the transgressions that was being relied on.
Correct.
Okay.
Yeah.
And then when the judge is making a decision about how much time to revoke, here there's concern expressed that the judge relied solely on probation failures. And is the concern additionally that the probation failures weren't adequately described, or is it really truly just that you feel that the nature and circumstances regarding the underlying offense wasn't adequately taken into account?
There was no adversarial hearing about these factual allegations. They were never established in an open court. Mr. Mollica never got the opportunity to present a defense. He never had time to prepare a defense. It's a wholesale absence of due process surrounding these allegations. The third thing that the state articulated as a justification for this compromised form of due process is that the defendant gets lots of notice upfront about the things that could lead to termination. But that's exactly part of the problem, part of the point. The contract lays out all kinds of things that could lead to termination. For instance, it says 6 failed UAs or 6 missed UAs will lead to termination unless everybody else agrees. But hey, even 1 failed UA could potentially lead to termination. And it's all under this, discretionary decision that takes lots of things into account. The whole point of therapeutic court is that people are going to make mistakes in the program, but that the program will continue to work with the person up until a point where it's clear that it's not working. And so having a single mistake in therapeutic court, just because you signed a contract that makes clear that, eventually you could be terminated for it, isn't notice and isn't a roadmap so that a defendant can adequately prepare their defense.
Mr. I have a question about the fact that these issues weren't raised below, and getting back to our discussion earlier about how Mr. Mollica didn't appeal the discharge from wellness court based on the criminal mischief case. Doesn't that suggest that these issues were not obvious to him? And so how could they have been obvious to the judge? I mean, he didn't even appeal the criminal mischief case. So he's not arguing that he lacked due process in the process leading up to his discharge on that case.
I don't think that that inference can fairly be read from that decision. At this point, Mr. Mollica has served all of his time in the criminal mischief case. So one could also read that Mr. Mollica decided to appeal the PTR because that was the portion of his sentence that he hasn't served yet. I don't think that.
But he hadn't served the case, presumably, at the time he filed the notice of appeal, or served the time, sorry.
And Mr. Mollica isn't a lawyer, and Mr. Mollica doesn't know the elements of the plain error test, and I don't think that you can read from that an inference about what is obvious under the law, which is what this court decides, and which is what we are raising to this court. So I would ask this court not to read anything into the fact that only one of the two cases in Mr. Mollica's case was appealed. We don't know anything about the circumstances of that decision or why it occurred, but certainly this court needs to resolve the issue that's before it. I also just wanted to point out that there's nothing unique about therapeutic courts in Alaska. Therapeutic courts in Alaska are modeled on what other states have done, and those states have overwhelmingly been able to afford and provide due process in this context. There is no reason to think that it couldn't be provided here. There's nothing unique about this process that other states haven't been able to adapt for and provide for due process.
Ms. Jura, I'm gonna cut you off with, you can have 10 more seconds to make any final point.
Okay, thank you. I just wanted to say, I think that the state conceded that Mr. Mollica didn't get due process when it said that there may be reasons that were never put on record that led to his termination. That's completely incompatible with due process. So I would ask this court to reverse. Thank you.
Thank you, counsel. We will take this matter under advisement and we stand in recess.